Good morning. It's Christine Faulkner with Cava&Faulkner. I am an estate and business planning attorney in Elk Grove, and we're here for another edition of Family Matters with Lana Shearer. So, Lana.
Good morning, Lana Shearer, family law attorney and mediator here in Elk Grove, and happy to be here for our next segment.
So today we're going to talk about something that is so important in estate planning and family law, which is the characterization of property. And when I talk to my clients about the different kinds of property, many times there's a lot of confusion. Most people don't really, they sort of get the difference between separate property and community property, but not really the legal characterization and how that's defined. And I don't get into it real deeply because it tends to be confusing, adding that into all of the concepts that we're talking about in estate planning, but we do talk about it, of course, because it's important. And so give us some education on the different kinds of property that you can have in California and how it's determined.
Right, absolutely. So in California, one of the fundamental principles of family law is that when you avail yourself of the benefits of being married and getting married in California, you also avail yourselves of certain benefits and privileges and obligations. So one of the fundamental ones is that after you're married, any property that you acquire, whether it be real property, personal property, no matter where it's situated, is community property, which means owned equally by both of you. Because in California, when you get married, you essentially form a partnership, a 50-50 partnership where everything's going to be shared. That's our public policy in California. Those are our community property laws. And one of the most basic one is you will create community property. So from that day forward, the day you say I do, you will begin to create community property. And that is regardless of which spouse earned the money that went to purchase the community property, or which spouse did the labor and which one stayed home, and anywhere that it's situated, not just in California. If you purchase property somewhere else, it will still be community property. So that's a fundamental principle. It's Family Code Section 760. And that's where we start, is that there's this presumption that anything you acquire during your marriage is community property. The other characterization of property is, of course, separate property, which separate property is defined under the family code as anything that is acquired by gift or inheritance, or if it is acquired by, pardon me, if it's earned while you are separated, so if a couple should separate, doesn't mean legal documentation has to be drafted, but if they had a period of separation and they acquired something, it'd be a matter of proof, but you could say that was separate property. And then if it's traceable to a separate property source, and that's something that we deal with in family law a lot, is that tracing aspect. But we start with the general principle that everything you acquire during your marriage is community property. So it's a big deal. And this is a very common, it's a very common litigated issue in family law. But I'm curious to know first, if you're helping a couple plan set up their estate plan, how do you deal with the community property issues if they come up while they're creating their plan?
So before I start on that, I do have one other question. So property acquired before the marriage is also separate property, correct?
Yes.
Yeah.
Yes. So I'm sorry if I didn't say that. So property acquired by gift or inheritance, or of course, anything that either one of them had prior to marriage is separate property. So there's the way it goes is anything acquired prior to marriage is separate property. Anything acquired after separation is community property. But anything acquired during that period of the marriage is community property.
Okay. So I'm going to say something that I think will lead back to a really great question for you. So when I meet with a couple to create their estate planning, we do talk about the characterization of their property. And the vast majority of the folks that I work with tell me, regardless of the source of the property, whether they had it before marriage, whether they acquired it during marriage, that they consider it all to be community property. And they have commingled or titled it in such a way that would, for all intents and purposes, lead an outsider to believe that it is community property because it's held in both of their names. It's not necessarily held, in community property. That's a discussion I have with clients a lot about their real property, how it's actually titled.
Mm-hmm.
Most of my clients come in with a piece of real estate held jointly in joint tenancy. But they've created, whether they know it or not, they've created a plan through titling that enables the survivor to receive the entirety through holding it in joint tenancy. Even if it was a property that was owned before marriage, they've jointly titled it. And but the vast majority, not everybody. So I do have clients who married maybe a little bit later in life or felt like they had a lot of success separately
Mm-hmm.
in a business. And it's really important to them that they keep their property separate. They have kept it separate even after marriage, meaning they kept it in a separate account. They didn't commingle. They didn't create a joint account and put that money into a joint account. And, they hold the business separately in their name, regardless of the business entity. And so it can get complicated, especially creating a joint plan. We talk about taking title in the joint trust, but keeping the trustee, meaning the access to that type of account is kept in the one trustee's name, not both. So it doesn't give the spouse access to an account that may have always been held separately, but it gives it the protection of the trust. And there is language in the trust, and sort of like for lack of a better word, the preamble, the beginning section of the trust that says the title and the legal character of the property is maintained, meaning immediately preceding putting it into the trust, if it's held separately, it still maintains its separate property nature, even though you're technically changing the name to perhaps one of the trustees into the joint trust. So there is language in the trust document itself that the parties agree that the property maintains the same legal character. And so I want to just mention that there are different types of property agreements that can be created, such as a transmutation agreement, which literally transmutes separate property into community property. And I don't complete those because I tell clients during meetings that, decisions regarding the nature of your property can have long-lasting effects. And while you are in a loving relationship now, if you were ever to divorce, this could come back to bite you. And this is not my area of specialty. I am not going to create that document for you. If you really wish to transmute all of this property to community property, then you probably should see a family law attorney and really get proper advice so that you fully are educated and understand the ramifications of your decision. So I'm curious, Lana, when people don't know about separate and community property, is it true that you can take a separate property asset, such as a house, and convert it into community property or quasi-community property when you have a mortgage or you have improvements on the house that are made with community income, even though it started out as a separate property asset?
So great question. But first I want to go back, and I think that's fantastic, the language that you use at the beginning of your estate plan, that you are not changing the character of the property in this agreement. That is priceless. And I hope other estate planning attorneys are doing that as well, because that is key. You're planning for their estate plan in the event of a party's death. That has nothing to do with family law. In family law, we are handling the division of their property in the event of a divorce, and completely different different considerations. They're at a very different place in their life. So I love that. Keep doing that. I hope other people listening to this will do that. Clear indication this is not changing the characterization of these properties. Love that. But yes, there are ways that over time, something that might have been separate property can develop a community property interest. So there are clear ways that you can take something, as you mentioned. You can take something that's my separate property, and I can decide I want to gift that to the community, if I were married. And that's a transmutation agreement, Family Code 852, where you can write out your specific intent. I understand this is my separate property, but I want to gift this to the community and consider it community property. I understand what I'm doing. I'm not being coerced. And you sign and date it. That's a very clear indication. But of course, as you know, very few people actually use that type of agreement. And instead, they might just treat the property as community. You're both living in it, you're enjoying the benefits, you're paying the mortgage with community property. Even if this house may have been purchased by, let's say, wife, 10 years prior to marriage, but has a mortgage on it. And then husband moves in when they get married, and they continue paying the mortgage for the next 10 years, out of their earnings. Their earnings are community property. But it doesn't necessarily change the character of that property as wife's separate property. But the community does develop an interest in that property, because with the payment down on principal, and perhaps there were some improvements, things of that nature. So while it still doesn't change that initial characterization, it does over time give the community an interest in the equity in that property. And there's various things that we use to determine what the amount of that interest is. Very dependent on how much time this went on and how much principal was paid down. We look at a lot of different things, but I will say that the characterization, the underlying characterization, kind of remains the same unless you clearly change it.
So how dependent is what happens during divorce on people keeping really good records? Because, my experience with most people is they don't. They don't remember when they started paying, when the community started paying. And I imagine that has a pretty deep impact on the outcome during, one party is going to get a nasty surprise. Right, because they can't produce the documentary evidence supporting the when the community started paying.
Well, it's not necessarily dependent on when the community started paying, it's the date of marriage. So the parties will start accruing community property, acquiring community property from the date they're married. So from the date that you are married, every dollar you earn after that date is community property. So even if husband was a stay-at-home husband and never worked, but lived there and they were married, and then wife is paying on the home, continuing to pay the mortgage with her earnings, she is now using community property to pay that mortgage. Things change as of that date of marriage. It's a big deal. If you're going to decide to get married in California, you are going to take part in the community property laws of California, unless of course you do a very solid premarital agreement. You're going to accumulate and accrue community property. So that's the date that we use, is the date of marriage, until, of course, their date of separation. So you might develop an interest in that property. Same thing for a business. If there's a separate business, but once you get married, then a person is running that business with their efforts. They're working in the business every day. They're earning money from the business. That's community property income they're earning now. Even if it was their separate property business prior to marriage, once they get married and they're still going to work and earning those dollars are now community. They're not separate just because it was your separate business you had prior to marriage. And so it's a really big deal if you're going to get married in California, that you understand that things will change, not necessarily the separate property character of that business. That will, unless something else changes, that's still the separate property business of the person that brought it into the marriage, but there will be some community property interest that grows over time. So it's really interesting and fun and highly litigated.
I bet. What was I going to ask you? Sorry, I just kind of went completely blank there. It was something about, well, can you tell us what quasi-community property? I know what it was.
Mhm.
Is there a way to, aside from, I'd like your opinion, on premarital agreements and how to make them effective for people who want to do that. But well, yeah, let me just ask that.
Okay. So premarital agreements are a vehicle that you can change the application of community property laws to what you are going to acquire or accumulate during marriage. So as long as it's very clear, fully informed, both parties should be on relatively equal footing, and have to disclose everything financially between them. So disclosure is really important when entering into this type of agreement. It's best if you have two people who have significant assets of their own and then want to keep those assets separate. And then you can control, are we going to communicate? Are we going to create community property during our marriage? No, everything we earn is going to be separate. Interest and retirement accounts are going to be separate. And everything that we own now is going to stay separate regardless of our behavior during marriage. And you define what that's going to look like. It needs to be very clearly defined. One of the issues with prenuptial agreements is it's one of the very few agreements where when a court's looking at, should I enforce this? They look at it at the time that they're enforcing it. Is this equitable now? And it's so many things can change between now and then that I don't favor prenuptial agreements at all, because I think they're highly litigated. They're often not followed. They're often not followed by the people that created them. If you create a prenuptial agreement, that contract that you're going to keep things separate, you need to keep things separate. You need to follow your own rules and your own contract. And more often than not, people don't. They create this agreement, this is how it's going to go. And then they just commingle everything and create, community property everywhere. They don't follow their own agreement. So it's of no value if you don't follow it.
Interesting. Yeah. And I'm sure people don't know that.
Right.
One other question. My understanding was that in order to have a valid prenuptial in California, you also have to have separate counsel. You can't go to the same lawyer to create it for both of you. Is that right?
True. Yes. It's not something we're going to create in mediation. It's something that each party should have representation so that they have advice on the legal effects of this agreement, make sure they fully understand it. So that is one of the requirements. And there's also time requirements. You don't want this to be signed, 7 days or less before your marriage. And that's a little bit, that can be evidence of coercion. Oh, here, our marriage is in 5 days, sign this. That's not how we want it to go. We want it to be started well before the wedding date and have lots of revisions and review and lots of informed discussions between the parties and their counsel. And that, lends more credibility to whether these agreements were, fully informed and well thought out, not just kind of a shotgun. We're getting married in 5 days, so sign this, or I'm not marrying you.
So I just, in closing, I want to say that I imagine for people who do get prenuptials, it might be useful to go back to their family law attorney every once in a while to get a reminder of what they need to do to keep that agreement effective. One of the things that I do in estate planning is I schedule into my practice reviews with my clients to remind them of the stuff that they need to do and why, because people forget. And so it just kind of brings to mind how, following, like you say, your own rules in the document that you wanted to create probably requires some maintenance, just to remind people to do the right thing, to make sure that the impact or the effect of their planning actually comes to fruition if they ever need it in a divorce the way that they expect, because they've been educated all along the way in terms of what they need to do. So
yeah, no, that's a great idea. Absolutely. You should have a 3 to 5 year check-in and make sure you're following your own rules. And maybe things may have changed, and maybe you need to do some amendments, honestly, because again, we're going to look back and see if it's fair now. And if one party happened to just accumulate all these assets through, whatever reason, it might not look fair. And, you might want to revise it. And maybe you always want to have some carrots for the other party. Is like, hey, if in the event of a divorce, you're going to get blank, you're going to get X, and make X attractive enough that they're not going to want to fight over enforcement of this agreement in court. Because if one person is walking away with significantly less, and maybe that things that were not anticipated at the time they created the agreement, well, that's, you want to fight it out in court about whether or not it should be enforced, or do you want to offer a carrot, offer an X that would make it attractive to just walk away and both be reasonably content. But that's an issue for another day.
Yeah, interesting. Well, we're going to bring this particular episode to a close. So thank you so much, Lana. That was highly, highly educational for me as well. And we're going to continue we're going to continue our series on property. So stay tuned to our next Family Matters. Bye.
Thank you. Bye.